You are
Anjali,
on
we
mute.
can't hear. Yes.
Oh, am I audible now? Thank you. Thank you. All right. So, good evening, everyone. I'm Anjali Singh. I'm the student convener of the Moot Court Society of Law Center 2. And I welcome you all to today's webinar on legal research and memorial drafting. Keeping up with our commitment to help our members and all the attendees to our webinars become better mooters, we are back with another workshop, this time to tell you about two integral skills of successful mooting, which is efficient research and effective drafting. We have with us today Mr. Daksh Aggarwal. Daksh is an alumnus of Campus Law Center, class of 2021, and the current editor-in-chief of Student Delhi Law Review, one of the law faculty's foremost peer-reviewed law journals. During his time at CLC, Daksh has not only been an avid mooter, but also an enthusiastic mentor to several teams participating in constitutional competition and insolvency law moots. I have had the unique privilege of being a member on the editorial board headed by Daksh, and I'm delighted to have him on board to share his expertise with us. Thank you for joining us and being our mentor today. Before we begin, I would request all the participants to keep their audio and video off throughout the webinar, and your questions will be taken up later during a Q&A session. Without further ado, I invite Daksh to please address our participants.
Yeah, thank you, Anjali. Thank you so much for such an effusive welcome. I'm grateful to the Moot Court Society of Law Center 2 for inviting me. Most importantly, I'm thankful to all the participants, our Google Meet participants and YouTube participants who have joined us today. And before I start, I would like to wish everyone a very happy Martyrs Day. Today we celebrate or commemorate the death anniversary of our father of nation, the Mahatma. So let's just start. Anjali, shall we proceed?
Yes, Daksh, please go ahead.
Yes. I hope my presentation is visible.
Yes, it's visible.
Yeah, thank you so much. I hope it's moving as well.
Yeah, yes, it is.
All right, thank you. Okay, so first of all, this is the general overview of the presentation. So please have a look. This is how we plan to proceed. So first of all, we will have some ground rules, the rules which we request you to observe so that we can ensure the smooth running of our event. Then we'll discuss what mooting is all about. Then some important points that a mooter has to take into consideration. Then 3 stages of research, stage 1, stage 2, and stage 3. And this is followed by some tips on memorial drafting. I hope this is clear.
Yeah.
Now, here are some ground rules plus some basic information. So the first thing, session is for 1 to 1.15 hours. Then we'll have a Q&A round. But if you think that your question is extremely important and it cannot be postponed and demands our immediate attention, then you can surely intervene and ask your question. Second, if you think that I'm moving too fast or you're not able to comprehend something, then you can ask me to slow down, or you can also ask me to repeat anything, right? The third one, using chat box for questions. So this is the preferred way. This is the preferred mode. Please turn off your mic because we don't want any kind of disruption or any kind of disturbance. Then the fifth one, this applies to all of us. Check your internet connection. If there is any issue, please get it resolved. I'll proceed. Okay, so what is mooting? In the previous session organized by the Moot Court Society LC2, Ms. Sonali Khatri did answer some of the most important questions. So, for example, what is mooting? Why should one participate in a moot court competition? How can a person form their dream team? So I'll not go into details, but I'll just give you an overview just to refresh your memory. So in my opinion, the definition given in the Oxford Guide, there is this mooting guide published by the University of Delhi. It describes what mooting is all about. So a moot court competition stimulates a court hearing in which the participants analyze a problem, B, research the relevant law, C, prepare written submissions, and D, present oral arguments. So in a word, moot court competition is a mock court. It's a simulation of a court. But the necessary question is, what kind of court? It is actually a simulation of a court of appeal. It doesn't deal with trial courts. For trial courts, you have a different competition altogether, and that is trial advocacy. All those who have been participating in moot court competition must have noticed this, that in moot court competitions, you don't get an opportunity to examine, cross-examine, or re-examine your witnesses. Right? So there is a difference between these two, and we will focus on moot court competitions today. Now, before we start researching, this is the most important thing. So before you straight away get to the researching part, there is this warm-up that you are required to do. And this important warm-up is a desideratum. I'll tell you why. So the first thing, studying the best memorial. If you're participating in a competition, it is crucial for you to study the best memorial of the previous edition. Both the petitioner best memorial and the respondent best memorial, because this will give you an inkling of how the arguments are structured. This will give you an idea how memorials are drafted. And there is a caveat here, don't copy lock, stock, and barrel. I mean, you'll have to apply your brains, of course. And if you like their approach, if you like their strategy, you can surely adopt their format as your template. But don't copy it, because your arguments are very different from their arguments. Right? Now, coming to the next part, going through the rules, competition rules. I'll share one document with all of you. Okay, so this document, which deals with the rules of the competition, is important because it'll tell you how you have to structure your memorial, how you have to give shape to your memorial. So the first thing, it can tell you team shall cite all authorities in the written submission using footnotes, following the blue book method of citation. So it can be any citation style, whether it is blue book or Schola, ILI citation style. So please focus on this. If they have specifically mentioned that you are required to follow this citation style, or you are required to use this citation style, then you are not allowed to deviate, right? And the second most important thing is penalties. I'm focusing on written submissions. I'm not focusing on oral submissions today. I mean, oral arguments. So this is the thing, written submission. So for example, if you look at point 6.3, it says that these are some mandatory heads which must be included in your memorial. For example, cover page, table of contents, list of abbreviations, index of authorities, so on and so forth. And now if I talk about the formatting part, please have a look at point 6.9. So it says that the page size should be A4, font type should be Times New Roman. And if you do not follow what they ask you to follow, then you will surely be penalized. So for example, if you fail to comply with rule number 6.3, then 1 mark for every head omitted, 1 mark for every page in excess of page limit as well. So there is a prescribed page limit, there is a prescribed word limit, and you are not allowed to exceed that limit. If you commit any mistake, you lose marks. So please take care of this before you start researching or start drafting your memorial. Then the most important thing, reading the moot problem. Now, this reminds me of this best advice which was given to Mr. Fai Nariman, and he even mentions this in his autobiography, Before Memory Fades. So he says that the most important lesson that he learned was from C.K. Daftari, a former Attorney General, and that lesson was that you don't just have to spend time reading your briefs, spend more time reading your case. And this is what I want to say, that spend more and more time reading a moot problem, because then only you will be able to identify some important issues. Then only you will be able to decipher or decode how you want to proceed. So let me give you an example. This is a strategy that I used to follow. So what happens when you participate in an international moot court competition, or when you participate in any moot court competition, sometimes the problem is very long. It is fact heavy. and you're not able to deconstruct it. So the best advice is divide it into stages or divide it into parts. Let me give you an example. Let's say there is a moot court competition which is on insolvency and bankruptcy code. It deals with insolvency law. And the first part of the problem deals with India, and the second part of the problem deals with the United States of America. Now there is this company called Company A, and this company manufactures and sells mobile phones in India. The first part of the problem, part A of the problem, says that there is this company A and it manufactures and sells mobile phones in India. But the part B says, or part 2 of the problem says, that the company is now planning to expand its operations, or they've already expanded their operations and they have an assembly unit in California and some assets in California. Then now CIRP, Corporate Insolvency Resolution Process, has been initiated against this company. Now, what will you do? Now, if I talk about Indian scenario, that is very clear. But when you talk about the United States of America scenario, then in this case, cross-border insolvency mechanism comes into the picture. Now, how will you decipher which section or which provision of the law you should apply to your case? Now, this is how you can break your problem in stages, or this is how you can divide. So the first part of the problem dealt with India only, but the second part deals with the United States of America. And then you start connecting these two parts. Because if you will start connecting these two parts in the very beginning, you will get confused and you will see that this problem is terribly convoluted and you are not able to decipher anything. So this is especially for problems which are very, very fact heavy. So there are many companies involved, or there are many individuals involved, and there are many governments involved. If I talk about international moot court competitions, right? Then it has got two aspects attached to it. One is identifying legal maxims, if there are any, in the moot court problem, and then identifying statutes or legislations or laws which are already given in the moot problem. So sometimes it is given that this is against Article 14, or the one party argues that this is against Article 14 or against Article 21 of the Indian Constitution. Or you will be able to identify issues that you want to identify. So there are some issues which are already given in the problem, and there are other issues that you want to identify and take it forward. Decoding part I've already discussed, that you can break it in stages and then proceed. Now, the next part, creating a timeline. This is very important because you must know the dates at which some important events occurred. This will allow you to retain some of the most relevant information. Every information is not important. There are some facts which are trivial and they won't add value to your research or your memorial drafting. But there are some events or some developments which are very important, and you must note this down. Then analyzing from every conceivable angle. All those who have been participating in the moot court competitions know that you have to represent both the sides. You have to be in the petitioner's shoes, then you have to be in the respondent's shoes. So you have to bring a fresh perspective to the table every time, right? Now you should again go back to your problem, reread your moot problem just for verification purposes, just to see whether you are progressing on the right lines or not. Are you able to analyze the problem? The timeline that you drafted matches the timeline given in the moot problem. So this is something that you have to do. So reread your moot problem. Now, last step, unlearn and repeat. Now, you had realized that the strategy adopted by you is not the best strategy by the time you reach the last stage. Last stage is rereading the moot problem. You thought that this was the best strategy, but this is not the best strategy, and you have to think about something else now. But what if your strategy is the best? Still, unlearn and revisit, rethink, and make revisions. Why? Because you have to represent both the sides, petitioner and respondent. Sometimes you get so confused, you think, okay, this case law number 1 is applicable to respondent side, but that may not be the case. That case is actually applicable to the petitioner side. So don't get disheartened. I'll just give you 3 R's. revisit, rethink, and revise. That's it. So even if you think your strategy, you're progressing on the right lines or your strategy is good, doesn't matter. Go back to your mood problem once again and repeat all these steps. Right? So this is an important warm up before you get onto that research part. Now, legal research stage one. As rightly said by Lord Bowen, an English judge, cases are won at chambers. Because if you do not know what your case is all about, then what will you present? If you do not have enough or sufficient material to corroborate your claims, then how will you argue? So this is absolutely true that cases are won at chambers. Now, facts of the case are your best friends. This reminds me of what Carl Sandburg, an American poet, once said, that if the facts are against you, argue the law. If the law is against you, argue the facts. If the law and the facts are against you, pound the table and yell like hell. So if you think that the law is not in your favor, facts might come to your rescue. So facts of the case are your best friends. You must know that this event happened on that day and why this event is important. So there are three questions that you must ask yourself and should be able to find answers of all these three questions. First, what happened? Second, when did it happen? And third, how did it happen? And you will be able to answer all these questions only when you are familiar with your mood problem. Otherwise, not. Right? Then identify key issues and prepare a research plan. As I said, that there are some issues given in the mood problem, and there are some other issues that you want to identify and you would like to bring to the fore. So that totally depends on you. And then prepare a research plan. This is very subjective. I think I can discuss my strategy, but I don't know what your strategy is. So your methods are very different from my methods. So as I said, that you must have a timeline, but there are people who are not willing to create a timeline and they can just go ahead with the research. So that depends. Now, acquiring foundational knowledge of the law. This is especially for esoteric subjects. Most of us are familiar with constitutional law or civil law or criminal law. I'm talking about substantive law, not procedural law, because most of us don't even know CPC and CRPC. But having said that, if I talk about foundational law, a foundational knowledge of the law, it means that understand the basics of law. If you think that you can resort to advanced research in the very beginning, then this is the biggest mistake. This, let me explain this to you with the help of an example. I don't know how many of you know that there is this competition, KK Luthra Moot Court competition organized by the Moot Court Society Campus Law Center. This competition deals with international criminal law. And in one of the rounds, Mr. Aman Lekhi, senior advocate and one of the additional solicitors Journal of India, was one of the judges. And there was this problem in which a person committed some offense in Somalia. An Indian national committed an offense in Somalia or some other state. And Mr. Lekhi was not at all interested in this. His question was very direct. His question was, how will you apply Section 3 and Section 4 of the Indian Penal Code to your problem, to your case? Now, Section 3 and Section 4 deals with the, I'll just tell you, punishment of offences committed beyond, but which by law may be tried within India. This is Section 3, and Section 4 deals with extension of Indian Penal Code to extraterritorial offences. And to our surprise, all the participants didn't know what these sections deal with. So get your basics right before you start researching something which is beyond the scope of your problem. Right? Then coming to the fourth one, primary sources and secondary sources. So here are some sources. There are only two types of sources. First is primary sources, so the Constitution. If you have any statute, legislation, or any notification, rules and regulation published by the government of India or published by any state government, then you have case laws, judgments delivered by various high courts or various or the Supreme Court. If I talk about Indian case, then you have law reports, law commission reports, and in secondary sources you have legal dictionaries, encyclopedias, legal articles published in various law reviews. Then you have legal commentaries. So, for example, you have Professor M.P. Singh's commentary on constitutional law. Then you have other textbooks. And the fifth one is understand Google and subscription-based databases. I don't know how many of you have access to Manupatra and SSC Online, CaseMine, and other databases, but I'll still try to explain whatever I can. I'll proceed. So first thing first, using primary sources to get the basics right. Primary sources, as I said, that it includes primary sources include constitution or legislation or rules or regulations. Then just read the text, because your interpretation can be very different from the interpretation of any court. So there is no need for you to apply any rule of interpretation. There is no need for you to apply golden rule, mischief rule, or any other rule. Just the literal interpretation of that text. Just read it and try to decipher, okay, this is what this section deals with, and this is what this section prescribes, or any provision of any act prescribes. Right? Then, whether it's procedural or substantive, I hope you know the difference between these two. So procedural law deals with the how the business of the court is to be conducted, and substantive law tells you about the law which governs the rights and obligations of all the individuals, and it also prescribes punishment for offenses. And next one is who has the power. Now this is very important. This is actually related to statement of jurisdiction. Does this court have the power to hear your case or no? So let me give you an example. If I talk about NCDRC, National Consumer Dispute Resolution Commission. So if you file a case again, if you're challenging the order of NCDRC, then you can file an appeal in the Supreme Court. There is no need for you to move the High Court. So you should know that which court has the power to hear your case. If you are approaching the High Court when you should have approached the Supreme Court or any other forum, then this is a blunder. And this is a real gaffe. So you should know which court you should approach to and which court has the power to hear your case. Because otherwise your case will be dismissed. Because there is no maintainability. Right? Then there are 4 aspects or 4 important documents of a legislation or of any rule. So the first one is preamble, and the second one is objects and reasons. I don't know how many of you know the difference between these two, preamble and objects and reasons. If you have Competition Act 2002, and if you can refer to it right now, I'll just tell you. So if I were to give an example, statement of objects and reasons of the Competition Act. So the first point says, in the pursuit of globalization, India has responded to opening up its economy, so and so forth. This is statement of objects and reasons. This is not the preamble. The preamble is on the page number 3, an act to provide keeping in view of economic development of the country for the establishment of a commission. If you don't have any copy, let me just show it to you. So this is the preamble. Anjali, is it visible?
Yes, Daksh, it's visible. Just bring it closer to the screen, it will be visible.
Yeah. So this is the preamble. This is not statement of objects and reasons. But if I have to refer to statements of objects and reasons, this is the statement of objects and reasons. So you must be clear. And this is how you get your basics right. Because your judge doesn't know everything about your mood problem or everything that is related to your mood problem. He or she will ask you questions which deal with the basics. Like, okay, tell me what's the difference if you're referring to this act. What does the preamble say, or what does the statement of objects and reasons say? Then don't get confused. Then preparatory documents. This is another important document that you can refer to. If I have to give an example, BLRC, Bankruptcy Law Reforms Committee report, which was published in the 2015. And this committee recommended something to the government, and then Insolvency and Bankruptcy Code. The Insolvency and Bankruptcy Code 2016 came into the picture. So that was the preparatory document, BLRC. And there are many committee reports. There are many committees constituted by the government of India or the state or many state governments. You can refer to these committee reports. But you will have to say if these committee reports have any value, because they're not binding on the court. Courts may or may not refer to these committee reports or to the recommendations made by the people who were an integral part of these committees. So, for example, in this case, SR Steel case, it deals with insolvency and bankruptcy. When the judgment was authored by Honorable Mr. Justice Rohinton Fali Nariman, he said, he quoted what Arun Jaitley, what Mr. Arun Jaitley said, or what other members of the committee said. What Mr. Arun Jaitley said in Parliament, or what other members of the committee BLRC said, just to know why this law was important in Indian context. So you can refer to these recommendations or committee reports or documents, but they are not binding on courts. Right? Now let's moving forward. Okay. Gathering and evaluating research materials, stage 2. Looking at a broader narrative. As I said, get your basics right. If you can't get your basics right, then please do not move to advanced research or secondary sources, because it will be of no use. Then don't start interpreting because you are not a judge. As I said, that there is no need for you to apply any rule of interpretation, just except for literal rule, because you are not a judge. You are here to assist the court. You are an officer of the court. You are not here to decide the matter, but to argue the matter. So there is a difference between the two. Then focus more on secondary sources. Now let me tell you what secondary sources are. Secondary sources are not the law. They are just a commentary on the law. And the purpose is twofold. Why do you refer to secondary sources? The purpose is twofold. First, they may direct you to primary sources. So for example, if you're referring to any commentary or any journal, and they have cited this case Nanda Bharti versus State of Kerala, then Case of Nanda Bharti is not a secondary source. It's a primary source because it's a case law. But you got to know about this case when you were referring to legal articles or commentaries or any other book. So secondary sources direct you to primary sources. And the second is that they serve as persuasive authority. So for example, if you want to study CPC, you refer to Takwani. If you want to study company law in detail, you refer to Avtar Singh. If you want to study law of tort, you refer to Bangya. So these books have some persuasive authority. These books are valuable. That's why you are referring to all these books or all this study material. Right? Now, stage 2, gathering and evaluating research material. Legal dictionaries, article, book, commentary, and case laws. Case law is not a secondary source, as I said. It's a primary source, but I'll still would like to bring to the fore some important points related to case laws. Now, let's first just refer to legal dictionaries. Which one to refer? Other legislative or judicial guidance, and there is this case law. So there are many dictionaries available. You can either refer to Black's Law, you can refer to Oxford, and I don't know how many of you know this, but there is this legal glossary, which is published by the Legislative Department, Ministry of Law and Justice. This is quite comprehensive, and it includes some important terms, and you can surely refer to this legal glossary. It's opening. Yes. So this is just like Black's Law Dictionary. But you must understand that you should look for something that serves your purpose. There is a caveat here. If you think that there is another material available which provides enough legislative or judicial guidance, then there is no need for you to refer to any dictionary, because in that case, you are misleading the court, or you are not prepared, you are underprepared. Let me just give you an example. So this case, this is an important case, G. Ramaswamy versus the state of Andhra Pradesh. This was decided in 1972, an old case by the High Court of Andhra Pradesh. An important case, I'll tell you why. So just have a look at this, paragraph number 9. Although the dictionaries are not to be taken as authoritative exponents of the meanings of the words used in an act, it is a well-known rule of courts of law that words should be taken to be used in their ordinary sense, and the courts are therefore sent for instruction to the dictionaries. And dictionaries have been resorted to in innumerable cases for guidance of the courts in the absence of any legislative or judicial guidance. So here is the caveat. If there is no judicial or legislative guidance, then only you will refer to dictionary meaning. Otherwise, no. Then coming to article, book, or commentary. What is the authority? Now, this is an important question. You cannot cite anything written by anyone. I mean, if I write an article today and you cite it, saying that this, whatever is written by this person is considered authority, then you are completely wrong. As I said, if you want to talk about constitutional law, you can refer to MP Singh, Professor MP Singh's work. If you want to talk about CPC, you can refer to Takwani. They have some persuasive authority, right? So if I have to give an example, this is a very interesting story. All of us know about Kesavananda Bharti case. So in Kesavananda Bharti, Mr. Kesavananda Bharti was represented by Mr. Palkhiwala, Nani Palkhiwala, one of the best lawyers this country has ever produced. Then his opposing counsel was none other than Mr. H.M. Sirvai. And he represented the Union of India. He and the then Attorney General represented the Union of India in Kesavananda Bharti. And the moot question in this case was whether the Parliament is allowed to amend the basic structure of the Constitution, including Part 3 or other parts of the Constitution. And H.M. Sirvai, since H.M. Sirvai was representing the Union of India, he was against this, that yes, Parliament can amend anything. And Nani Palkhiwala was opposing this, of course. Now, the interesting thing happened. It's very fascinating that Mr. Nani Palkhiwala used H.M. Sirvai's constitutional work to substantiate his claims. So he said that there is one jurist, there is one famous Indian jurist who said this, that the liberty of an individual cannot be put to risk, something like this. And when the court asked, okay, who said this? And he said that this jurist is none other than Mr. H.M. Sirvai. So Mr. H.M. Sirvai in 1972, he was considered authority of constitutional law. He's still considered authority of constitutional law. So if a person like Nani Palkhiwala can use H.M. Sirvai's work, then all of us can, because it has authority. And if you cite his work in any court, then it will surely fetch you some brownie points. Now, any other development? So one piece of advice, don't be ignorant. For example, if there is this book or commentary published in the year 2018, constitutional law book or constitutional law commentary on constitutional law, which was published in the year 2018, and you have a competition in 2022, and you're still referring to 2018 commentary or 2018 book, then I don't know what to say, because you are not updated. Latest developments have not been included in 2018 edition. So refer to the latest edition so that you can have enough research material to back your claims, right? Then relevant footnotes. I don't know how many of you have a habit of reading legal articles which are published in various law journals. They have this. If I talk about Indian journals, most of the journals do not like explanatory footnotes. But if I talk about journals like Harvard Law Review or Stanford Law Review, they have explanatory footnotes. So for additional information, you can refer to footnotes. And these footnotes are very important and very useful, because if there is this case in the main body and there is a footnote which says see also this case, then you can explore that case as well, study that case and see if that case is applicable to your case or no. So it's not like that you just go through the main body of any article and your job is done. No, it's not like that. For additional information, you will have to refer to footnotes. And sometimes, let me give you an example. There is this sentence in the main body that several cases have been decided by the Supreme Court of India on this matter. This is just a sentence, but what about these several cases? Which are these cases? You have a footnote. Some 3 to 4 cases cited by this person who has authored that article. And these are some cases decided by the Supreme Court. And then you can examine each and every case and then see if that case is applicable or not. Then referred by courts. As I said, sometimes the Supreme Court or the various high courts refer to some books or commentaries. So you will have to see whether the book you are referring to or the commentary you are referring to has been cited or not, has been referred to by the courts or not. Because if they are referred, then your argument will be stronger, because then you can say that this same book was referred by the Supreme Court in this case, and I'm using the same reference to substantiate my claim or my statement. Right? Then you have case laws. Important questions. Any dissenting opinion, is it binding, good law or overruled, or need to distinguish? So the first thing, any dissenting opinion. You must study dissenting opinions because of 2 reasons. First, it gives an impression that you are an excellent researcher. Second, it tells the judge how the law has evolved over the years. Let me give you an example. All of us know that right to privacy is a fundamental right now. It's an integral part of, essential part of right to life and personal liberty enshrined in Article 21 of the Constitution of India. But if I have to talk about Khadak Singh versus State of UP, the case that was decided in 1962, the Supreme Court held that right to privacy is not a constitutionally guaranteed right. But there was a dissent. Justice Subba Rao dissented in that judgment, and he said that right to privacy is an integral part of an individual's personal liberty, and hence it is a fundamental right, as it finds a significant place in Article 21 of the Constitution of India. So from 1962 to 2017 or 2018, how the law has evolved over the years. You're bringing this to your judge's notice. This is extremely important. And then the judge will be really very interested to listen to your case. Okay, this is what happened in the history, and our demands are different now. 2017 India is very different from 1962 India. Right? So this is how you can proceed. Then is it binding or not? For this, you can refer to Articles 141 and 227 of the Constitution. 141 says that law declared by Supreme Court of India is binding on all courts. It's the law of the land. And Article 227 says that high courts can exercise the power of superintendence over all courts subordinate to them. But you must understand that if there is a judgment delivered by the Delhi High Court, that judgment is not binding on the Punjab Haryana High Court, or for that matter, the Rajasthan High Court. Right? Similarly, if there is a judgment delivered by the Madhya Pradesh High Court, it is not at all binding on the Supreme Court, because Supreme Court is the apex body. But if there is a case decided by the Supreme Court and there is a judgment, there is a verdict, that is binding on all the high courts, even if high courts do not concur with the view of the Supreme Court. Right? So you must understand whether whatever you are citing has persuasive value, or is it binding on the court. Then good law or overruled. Please do not cite overruled cases. Check once, twice, thrice, check as many times as you can, but do not cite overruled cases, because if you cite an overruled case, this means you are misleading the court. And then anything will not matter. What matters is that you have cited an overruled case and you tried, intentionally or intentionally, it doesn't matter. You tried to mislead the court, something that the court will not approve of surely. Right? And let me give an example. There is this legal maxim which says that whatever has been decided must be taken to be correctly decided. This doesn't apply to moot court competitions, because if something has already been decided, something has been decided must be taken to be correctly decided, then it means that you can cite overruled cases, which should not be the case. So something which has already been decided, question that. Okay, let me see if this case was overruled by someone, by the other court or not. Right? Other court means the Supreme Court, because we are talking about courts of appeal. We are not taking into consideration what happens in trial courts. Now, need to distinguish. This is a cool strategy. This is a cool strategy because sometimes you think that there is this judgment which is unfavorable or which doesn't favor your case, and then you still want to, and you think that your opponents can take an advantage. They will surely cite this case, and your case will be weaker. Then try to distinguish it on the facts. Tell the court that the facts of this case are very different from our case, and hence the doctrine that was propounded in this case cannot be applied to our case. So be assertive in that sense and try to distinguish it. Now I'm coming back to that same thing. Reread your moot problem. Get facts are your best friends, because you will be able to say that the facts of this case are very different from ours only when you are familiar or well versed with your case, with the facts of your case. You will be able to differentiate between the two and tell the court accordingly. Right? Then game of keywords, stage 2. For this, there is no ironclad rule or there is no straitjacket formula, honestly. Only experience can teach you how to research on Google or other research databases like Manupatra, CaseMine, or SSC Online. But here are some suggestions. This is the strategy that I adopt. So game of keywords, it says first one is too large as it is not subject focused. All of us know that Google is not subject focused. You will get many results. There are many findings. Some of them are unrelated. Some of them are related to what you want to know or what you want to search. So it depends. Then use of quotation marks. Some people believe in this. I mean, this is of some help, but not of great help, because when you put your question in inverted commas or in quotation marks, you don't get isolated findings. This is what I call isolated findings, because if you do not put it on in quotation marks, every word will be searched separately. So if I write what relief can be given by the court, you will have one result just on this word given, the other on delay, the third one on compensation. So if you put this entire question in quotation mark, then Google will be able to understand. But that depends. Sometimes you are able to get the desired answer. Sometimes you are not. Sometimes you're not able to get. So try and try. That's the only method. Hit and try method is the only method that can be made applicable. Then based on a real case. Now, when you have studied the facts of your case, look for a real case. I mean, people who are drafting the moot problem are not doofuses. They know what they are drafting. They know everything about the law. So, but if there is a case which is similar to what you want to find, then make an attempt. Otherwise, just focus on your research strategy. Now, sufficient to substantiate your claims. This is a question that you must ask yourself. Do you have enough material? It doesn't matter whether you have case laws, articles, something corroborated by commentaries or books. But if you have sufficient material to substantiate your claims, then it's enough. If you have at least 5 to 6 case laws, articles, and overall 5 to 6 research materials to substantiate your claims, then it's okay. You're done. Then follow this 15-minute rule. This 15-minute rule says that if you're able to find something within 15 minutes, then it's okay. If not, then change your strategy. Change the keywords. Let me give you an example. So I wanted to find something. So there was this case. I won't discuss the case, of course. The question was, what relief can be given by the court in case of delay in compensation? So this was the research question. Now, there were some keywords: relief, delay in compensation, and given by the court. Not given by any government, but given by the court. So here are 4 keywords: relief, court, delay, compensation. In my first attempt, I didn't get anything. In my second attempt, I changed relief. I replaced relief with compensation. So what compensation can be given by the court in case of delay in compensation? Then again, I couldn't find anything. And in the third one, I said interest given by the court in case of delay in compensation. And within 20 minutes, I was able to find a case law, a recent case law that was decided in the year 2021 the judgment delivered by the Madras High Court. So this is how I changed my strategy. Right? First was relief, then compensation, and then interest. That there was an interest given by the High Court of Madras. Right? So this is how you can proceed, and you will surely have your Eureka movement or aha movement. But when will you have your Eureka movement? I can't answer this question, because if you don't have one, this is what you feel. This meme, as it presents, I couldn't find a picture of a donkey, because this is what you feel sometimes when you are not able to get the desired result. You feel so worthless, and you feel as if you're no good to man or beast, and you don't know what you're doing. You have used 50 keywords, you're not able to get that one case law or that one article that you are looking for. But then please don't be crestfallen, don't get disheartened. But yes, at the same time, don't stop. Try and try. As I said, hit and trial method is the only method. There is no straitjacket formula. Now coming to the law of databases. The law of databases says that there is no law. If there is no ironclad rule, there are no rules. As I said, that you'll have to change your keywords again and again. But some suggestions: make it simple and concise. So you don't have to write the entire story. You don't have to write 2 to 3 sentences. Just look for those keywords and it's over. If you're able to find something, it's good. If you're not able to find anything, then hard luck. Then truncation is important. Let me give you an example. You want to know what employ means. EMPLOY means. Now, if you write employ, there will be many results on employ, employment, employer, and employee. But you're only looking for employ. You're not looking for employer, employee, or employment. So you need to be very specific that this is what you're looking for, and just write that. And you can also use quotation marks in this case as well to make sure that your research is restricted to what you're looking for and you don't get unrelated results. Right? And then the third one, learn to filter information. Learn to filter information means that you can just write, you have one option of free text. You can just write the name of the case or just write the name of the doctrine or the research question. Then you have find case law by section. This is the dashboard. Figure 1 presents the dashboard of SSC Online. Then find by citation. So you should learn to filter information. And then there is another thing. Are you looking for case laws or are you looking for legal articles? If you're only looking for case laws, then write that you're looking for case laws only. And if you're looking for case laws of the Delhi High Court, then specify that only the Delhi High Court, no other court. There is this option. All those who have access to SSC online or under Manupatra, they must be knowing. So filter your information. Otherwise, you'll get 1,000 results. And these results are not valuable, of course. Right? So do this task with fastidious care. Don't be ignorant and don't be, just don't give it to SSC online or Manupatra, okay, whatever they give it to you is actually correct. Then you can actually go to the Supreme Court website or the High Court website to check the status of that case, whether that case was overruled or whether that case was dismissed by the Supreme. If an appeal was filed, what happened to that case, whether that case was dismissed or admitted, what stage that case that case is at. Then these are some questions that you must ask yourself and try to look for answers. Then this is a fun fact. Do you know SSC Online does not accept verses, VS dot. It only accepts V dot and not VS dot. It doesn't read VS dot. Right? And then figure 2. Figure 2 is important for all those who are in their first year or second year. If you want to study an esoteric subject, so let's say arbitration or insolvency or competition. So these are some technical concepts, and not everybody would like to comprehend these concepts. So just to get your basics right, there is this option, curated topics on SSC Online. Click that. Go. There are many categories. If you want to, let's say, study insolvency and bankruptcy code, so there is one category, corporate and commercial law. In that category, you have another subcategory, insolvency and bankruptcy, and then there are many articles, topic overview, recent case laws, or recent developments, or recent committee reports. Then you can refer to. Right? So this is an important feature that you can explore. Then all these databases, needless to say that all these databases are one-stop solution only if you are experienced. If you are not, if you are a Tiro, if you are a beginner and you are still exploring, then it will take time. It is time consuming, but you will get a hang of it. Then explore other options to be doubly sure. As I said, if I talk about Manupatra, there are other options, Manu search, legal search, act search, results, so on and so forth. So horizontal plus vertical. If you want to restrict your research just to case laws, refer to case laws. You have Supreme Court, High Court, and if you're looking for a case, just say, okay, I'm looking for Supreme Court cases. I'm not looking for any other court case. Right? This, ending the never-ending process. I believe that legal research is never-ending. There are many aspects that you would like to cover, or there are many aspects which you think you have covered, but in reality, they're still left, and a lot has to be done. So the first thing, response must be intelligent, intelligible. You must maintain a logical train of thought. Okay, this is my question, this is the issue, this is my sub-issue, and this is my response to that issue. And that issue and that response must be in plain English, so that your judges, organizers can comprehend what all you have written. It should not be unintelligible. It should be intelligible. Then applying law to the facts. I will come to this when I'll discuss memo drafting. Then you have pick your best argument. So by this time, you know that, okay, these are some important arguments that I would like to put forth. And this argument is my strongest argument, or this argument is my most convincing argument. And I think that this argument can help me win this case. So that will be your first argument, right? And then please start drafting your memo. Why? Because you should have at least 2 to 3 drafts ready by this time. Because if you're done with your research and then start drafting memorials, then you will not be able to chalk out your plan clearly. You will not be able to put everything down to papers. right? So you are researching, and at the same time, you are drafting your memo. You're researching, and simultaneously you're drafting your memo. And you should have at least 2 to 3 rough drafts. Then reach a dead end. I mean, a person cannot be 100% satisfied, but if you think that you have 80% material, and out of this 80%, 60% is sufficient to corroborate whatever you want to convey, then this in a way means that you have reached the dead end, and you should focus on your written submissions and oral submissions. Now, what if the argument which you thought was the best argument is not the best argument, and you have already started drafting your memo, and you thought you adopted the best strategy when it comes to applying the law to the facts, but actually all this is wrong, because the case law that you were looking for is actually not the case. Those are not the cases you are looking for. You thought that this is the case that can be applied to my case, but actually this is not the case. Then what will you do? Repeat, revisit, rethink, and make revisions. Because sometimes this happens. You go through a case law, and you think that, okay, this case is the best case law, and I should cite this to make my argument stronger. But after referring to your mood problem or rereading your mood problem, you come to know, okay, this case law cannot be applied. Then the best argument becomes your worst argument. So this happens. So please be prepared for the worst. This is the bitter truth. But this will help you to gain some experience. Now this won't be time consuming for you, because now you know the process. This is how I have to research. This is what I'm looking for, because you are clear in your own head and what stage this case is at. Whether it was overruled, or whether the petition was dismissed or admitted, notice was issued by the Supreme Court, what actually happened in that case. Right? So this was all about legal research. If anybody has any question related to legal research, because memorial drafting is another concept that I would like to discuss. So far, so good. Are we on the same page? Or if you think I'm moving too fast, if you want me to repeat something, I can. I don't want this to be overwhelming or intimidating.
Daksh, there is a question in the chat box. So if you'd like to address that, you can do that. Or if you would like to proceed, we can do that and then have a Q&A. So how would you like to do this?
Okay, I'll just 1 minute.
Okay.
Okay, yes. How to check whether a case is overruled? I can answer this question. Okay, so this question was asked by Rishabh. I'm so sorry. Rishabh. Rishabh, as I said, that you can go to the Supreme Court website, or you can go to the High Court website. So there is this column, case status and judgment. And just write the writ petition number, or the name of the judge, or the name of the judge, or name of the case, or the year as well. And then you will be able to see that whether this case was overruled or not, or what state this case is at, right?
Thank you, sir.
And if you can access Manupatra and SSC online or CaseMind, so there is this red circle or red box that appears, which means that the case has already been overruled. But if you don't have access to these databases or these platforms, then please go to the Supreme Court website or to the High Court website. Sometimes it's so tedious, so taxing to find if the case was overruled or not, because these websites do not work properly, and you're not able to find that case. But I mean, it depends on your luck. If you're able to do it, good. If you're not, then ask your friends who can access Manupatra or SSC online. Now coming to memorial drafting, the second aspect of today's discussion. Anjali, this is visible, right?
Yes, Daksh, it's visible.
Okay, thank you. Okay, so memorial drafting, the writing that matters. Actually, there are two writings that matter. First is your law article, and the second one is memorial drafting. And more or less, they are same. I mean, the strategy that you adopt for or that you formulate for memorial drafting is more or less the same that you adopt for legal articles. But the focus is on memorial drafting today. So I hope you know what a memorial is. So written submissions, you can call it written submission, memorial, skeleton argument. You can give it any other name. So the written submissions made by the petitioner and the respondent. Ref means your memorial, and this is like a petition. So you tell the judge about some important developments that took place. You state the facts of the case, and then you tell them about about your case, and how would you substantiate your case. So there are some grounds. I'm talking about the real petition, but the format of the real petition is very different from what you are required to do in your memorials. So first thing, don't teach the law. Please remember that judges are not your students and you are not their teachers. They know what the law is. They know everything about it. So please don't teach. Some people have a habit of discussing legal theories. So I believe that Constitution is the grand norm. Kelson said this. H.L.A. Hart said this. Legal theories or something related to sanction, which was propounded by Austin. So no need to mention that, because that will surely not add any value to your case. Second, regurgitating facts versus misrepresenting facts. The regurgitating facts means you're just stating the facts. If you want to state the facts which favor your client, then do that. But do not misrepresent or misstate anything, because in that case you're misleading the court. Something that didn't happen, and you have written that okay, all this happened and the opposite party did this to my client, something like this, but that never happened. Then you are concocting, then you are cooking up stories, and this is not this cannot be an integral part of the facts of the case, right? Then spotting the right issue. As I said, there are some issues which are given in the problem, and there are some issues that you want to identify. But please do not identify issues just for the sake of it. If you think that this issue is really important and this issue is not given in the MOOT problem, then you can have another issue. But please focus on the issues already identified in the MOOT problem, right? Then you have play your cards right. This means, okay, I don't know how many of you know this, but your memorials are shared with your opponents as well. So if you're participating in a MOOT court competition, your respondent memo, your petitioner memo will be shared with your opponents. And if you reveal everything, then your opponents will get an opportunity to issue point by point rebuttal. They will be able to negate all your arguments. So play your cards right. This means hold your cards close to your chest. There is no need for you to reveal everything in your written submissions or in your memorials. So you need to be very, very, very careful. Something that you would like to include in your oral submission and something that you would like to exclude from your memorials. That is your decision, that is your call. Then names of parties. Now this is very interesting. Sometimes I'm so sorry. I witnessed this myself. There was this competition, and there was this MOOT problem that dealt with the defamation case. So in that defamation case, one party said that this is the case A versus Union of India or State of Haryana. But the other person said that no, this is not A versus State of Haryana, this is A versus B. Now, all of us know that defamation case is a criminal case. It's a criminal Section 499 IPC. But it's not an offense against the society because it doesn't shock the conscience of the society as a whole. All right, you are leveling allegations against someone, but against an individual. It has got nothing to do with the state, or it has got nothing to do with the society. So get this right. And the first question that was asked by the judge was, why did you write A versus State of Haryana and why not A versus B? And the judge spent 15 minutes on that question because he was able to counter the participant for obvious reasons because this was wrong. And the participant was not able to justify, was not able to defend his case. So get it right. Then here are some important aspects related to memorials. One is plain English. The other one is page numbering, headers and footers, citation style. So these aspects are related. These are formatting or presentation aspects. First thing, plain English. As I said, that your response must be intelligible. Don't use complex language. Don't use something which the other person cannot understand. And let me give you an example. Just remember this. Kanhaiya Lal, Mr. Kanhaiya Lal, one of the greatest lawyers of India, he said that plain English cannot be subverted to suit a particular point of view. So when your language is transparent, when your English is plain, it cannot be subverted to suit a particular point of view because you'll have to assign literal interpretation to it. You cannot interpret it the way you want it, the way you want. Or you cannot apply any other rule of interpretation. So it should be plain English, readable, understandable. Then citation style, as I discussed, when I was referring to that GNLU, GIMC moot court competition rules, that you have to follow the Blue Book citation style. So maintain that uniformity. If you don't know anything about that citation style, study that. Ask your mentors, ask someone who is familiar with this style, because there are two styles which I personally think are quite difficult to understand. One is Oscola and the other one is Blue Book. Indian ILI citation style is quite easy to understand. So if you know someone who can guide you, then please ask that person. Then you have headers and footers. Now let me show this to you. So this is the best memo that was submitted when there was this competition, GNLU International Law Moot Court Competition 2019, and just have a look at this. So they have this header, 11 GNLU International Moot Court Competition, and they have this footer, written submission for the complainant. Most of us do not even know how to add headers and footers, and most of us don't even care. But this should not be the case, because this will make it more, because these aspects, these are very, I won't say trivial aspects, but there are very small aspects which will add value to your memo because they make it more presentable. Now, if you see this, now this is Roman numeral. 1, you have 2, you have 3, you have 4. But if I talk about legal pleadings, you have cardinal numbers here, 3, 4, 5. And look at the space. This person has maintained uniformity. So it's not just about your arguments when it comes to written submissions, it's also about the shape that you're giving to your memorial. So indentation, alignment, font size, font type, everything matters. If there is an extra line, that because of that extra line, you might lose marks. So please take care of all these aspects while drafting your memo. And this is just to give that final touch to your memo. If I talk about the rough drafts, then you may or may not focus on these aspects. Because at that time, putting forward the most compelling argument should be your priority. But while you are drafting your memo, while you're drafting a skeleton argument, these factors or these aspects do matter. Then you have the most important rule, universally accepted rule, IRAC rule, giving shape to memorials. So it stands for IRAC, issue, rule, applications, and conclusion. Now, if I talk about issue, the I part of it, it says avoid open-ended questions. Why is this important? Be assertive. So the first question that you should ask yourself, why is this issue important? If you are introducing another issue, I'm not talking about those issues which are already given in your mood problem. If you're introducing another issue, why is that issue important? Why should you discuss it? Right? Then avoid open-ended questions. Let me give you an example. So you won't write that whether Article 14 can be applied to my case. This is not an issue. This is not a question. You must write, be assertive, and be firm and say that the petitioner submits that offender-based classification violates Article 14 of the Indian Constitution. So you have to be assertive. You don't have to write open-ended questions. I mean, whether Article 14 applies to my case or not, this is not a question. What are you saying? Does Article 14 deal with personal liberty? No, it deals with equality. So please be specific and please be assertive. Then rule. Funnel approach, view objective, explain the rule. Funnel approach means that look at the broader narrative. That broader narrative means that if you want to introduce equality to your case, then you are discussing the principle of equality, right? Article 14 of the Constitution. Now you want to talk about one classification. That classification should be based on two important factors: intelligible differentia and rational nexus. So you have principle of equality, a principle of equality, that's the broader narrative, and then you are coming down to intelligible differentia and then a rational nexus. So this is the funnel approach I'm talking about. You cannot directly come to intelligible differentia and rational nexus without even discussing what equality means, without even discussing what Article 14 says or prescribes, right? Then explain the rule. Explain the rule doesn't mean that you will just write 2 to 3 sentences. Explain it properly so that the other person can decipher what you want to say. Then application, draw your analogies and carefully apply it to the facts. I've already discussed this, that you must be familiar with your facts and then start applying the law. And if you have a case law, and if there is a significant overlapping, or even if there is any similarity between that case law and your case, then you can surely apply the facts of the law to your case, right? But I'm not saying that the facts should match. There can be some difference, but look for that similarity. Look for that lowest common denominator. Look for that common factor, right? Then conclusion, this is very simple. Just state the outcome in 2 to 3 sentences. You can use words like in sum, in conclusion, therefore, hence, thus, and your judge or the organizer will get to know that this is what you want to say and this is how you want to conclude. Now, typical structure of memorials. Now, strategies can be very different. However, one team means one voice. So this is the point you want to reach. This is the bliss point. I mean, this is your Eureka moment. This is the point where all of you will be very happy. But there are different paths. Path 2 says that you must focus on case laws, but Path 1 says that you should only focus on articles or commentaries. So adopt any one strategy, but do not ignore or neglect the other one. It should not be like that you have not explored the other strategy at all, because the judge will ask something related to path one. You have adopted path two, strategy two, but the judge would like to ask something related to strategy one. So be prepared for that. And one team means one voice means if there is one person who is insisting that we should focus on case laws, and there is another teammate who is saying that okay, let's just focus on commentaries. So it depends on you. It depends on the entire team whether you would like to go ahead with the first strategy or the second one. That totally depends. But one team means one voice. This doesn't mean that for the first issue you were only referring to case laws, and for the second issue you were only referring to articles, and for the third one you were only referring to legal commentaries. So you need to reach a settlement, a mutual consensus. It's important. Then table of these are some mandatory heads. Table of contents. Use word tools. So just I don't know how many of you know this. Go to references. If go to references, and you will be able to add table of contents. It doesn't require any thing. Then write headings. Your headings should be absolutely right. They should not be ambiguous or should not have any double meaning. Then the index of authorities. Be accurate. Location is crucial. It means that you should have page numbers. So if you say that we refer to, I'll just give you an example. Okay, so this is the index of authority. Index of authority. So this person is referring to agreements and agreement on subsidies and countervailing measures, article this and this. So this is on page number or paragraph number 15813, whatever the case is. So be specific, and location is crucial. Just tell your judges, okay, this is what we have cited, and you can find this on page number this. Then statement of jurisdiction, knowledge of procedural law. I've already discussed this. You should know which court you should go to. If you are approaching the wrong forum, then it's your fault, right? And you will be penalized for sure. And the 1 minute. Right. And then you have statement of facts. As I discussed, regurgitating facts versus misrepresenting them. So favor your client. If you want to favor your client, it's okay, but do not present something which didn't happen, right? And then weave a story. You should be able to narrate the story. Okay, this is what happened on this, and then this happened, then this happened. So there should be a natural flow, a logical progression. Focus on that. Then measures at issue. Focus already given. I've already discussed this. That your primary focus should be on the issues which are already given in your MOOT problem. I mean, there is no need for you to deviate unless it is very necessary. Then sub-issues add value. If there is an issue which you think is a broader issue and some sub-issues can be included, then add those issues. But again, don't do it just for the sake of it. If it doesn't add value, then you will not do it. Then you have summary of pleadings, establishing link, and don't elaborate. Summary of pleadings doesn't require much expertise, because now when you know that these are your arguments, you just have to state, okay, this is what we are going to argue, and there is no need for you to explain or elaborate. Then legal pleadings, again, very important, natural progression. As I said, pick your best argument, pick your most compelling argument, try to substantiate it using case laws, articles, or whatever research material you have. That is corroboration. And if you are explaining, if you're focusing on first issue, let's say if you're focusing on issue 1, then your argument should progress naturally. Your argument 5 should not be completely unrelated to your argument 1. Because at the end of the day, all these 5 arguments are on issue 1. It's not like that argument 5 is on issue 3 and argument 1 is on issue 1. It's not like that. So there should be natural progression. And then last, prayer relief. You must remember that your memo is incomplete without prayer, because you have already explained your case. But what do you want from this honorable court? What relief do you seek? And always look for the best possible deal, because the court may or may not give you the best possible thing that you wish to have. And this is a graph. I'm so sorry. So this actually shows the relationship between argument strength and page number. Most convincing argument comes first, which means that the strength of an argument is inversely proportional to the page number. What I want to convey is that if you think that this argument A is the strongest argument on a scale of 1 to 10, you have assigned 10 points to this argument A. Then argument A should find a place on page number 1. It should not find a place on page number 4 or 5 or something, or it should not be like a passing remark. It's not like that you're building onto something. Your argument 1 is argument 1. Your argument 2 might be related to argument 1, but you must remember that your argument A or argument 1 is the most important argument. And this is the argument which will help you win your case. Right? So argument strength is inversely proportional to page number. On page number 1, you will always write your best argument. Right? And again, once you are done with your memorial, go back to your MOOT problem. Now, this time, study your MOOT problem scrupulously. See if you have missed anything. See if there is anything which should be included or which should be excluded. And I do think that even after reading your MOOT problem 10 times or 20 times, you will be able to discover something new the next time you read your MOOT problem. Right? So if you're done with this stage, going back to your MOOT problem is the step that you must not forget. Yes, thank you so much. If you have any questions.
Thank you for the incredible session, Daksh. So with your permission, we'll be moving on to the Q&A part, where we've included questions from our participants. We'll also be taking up the questions that have been sent in the chat box. I invite Vivek, our deputy convener, to lead this part. Vivek, if you could just...
Hi.
Yeah.
Hello guys, this is Vivek Maheshwari. Hi Daksh. I'm the deputy student convener of MOOT Court Society. So we'll be starting with the questions. So firstly, we'll start with the questions here in the chat box. So I think Daksh addressed this question of how to check whether a case is overruled. So Srishti Upadhyay asked, can we cite one High Court's case in another?
Yeah, thank you, Vivek. Yes, you can surely cite this case. Srishti Upadhyay asked this question, when can we cite one High Court case in another? Yes, you can surely cite that case. But please remember that this case will not be binding on the other High Court. This will only have persuasive value. If the High Court is convinced that, okay, we would like to go ahead with this interpretation, then it may accept that argument, but the High Court can exercise its discretion anytime. As I said that the judgment delivered by the Rajasthan High Court is not binding on the Delhi High Court, because two High Courts are very different.
Daksh, can you very briefly also tell us the difference between judgments that have persuasive value and those that have binding value? Just very briefly.
Yeah, persuasive value means that the court, as I said, the Delhi High Court may or may not accept it. It can exercise its discretion. But if there is a judgment delivered by the Supreme Court, then the High Court will have to accept the judgment, even the High Court doesn't concur with the view of the Supreme Court. So there is a difference between persuasive value. You can exercise your discretion, but when it is binding, you cannot.
Okay, so the next question is asked by Anupam Mishra, and he asks, in an induction proceeding, shall I talk about the case which my counterpart can cite to put forward his cause and distinguish it from my case?
Can you please repeat it, Vivek?
Yeah, surely. So he asks, Anupam asks, in an induction proceeding, shall I talk about the case which my counterpart can cite to put forward his cause and distinguish it from my case?
Yes, you can, but you'll have to be very, very careful because if you think that your counterpart or the opposing counsel has already cited that case and the that person was already able to convince the judges, then and that person was able to beautifully distinguish that case on the facts, then uh, it can be suicidal for you if you cite that same case again. I hope I've understood this question correctly, right?
Yes, Daksh, yes. So the next question is from Sharik Khan. He has asked a basic question like, how can we start making memorial and what type of resources we can refer to?
As I said, you should focus on secondary sources. So you can refer. Sharik Khan is from Faculty of Law. Is he from Faculty of Law?
Yes, sir. LC2.
Okay. So you can start reading your case material if you want to know something about, let's say, Article 14. Refer to your case material, refer to the Constitution, and you have a basic understanding of what this concept means, and then move forward to move forward. Then you start googling and you start researching using these databases. So first focus on First focus on secondary sources, specifically your case mat, books, and legal commentaries, because these are available. I mean, you can go to library and can have a look. And how can we start making memorial? As I said, study the best memorial study the best memorial of the previous edition, because you will then get an inkling of how memorial is drafted. So first get used to that and then proceed. And when you have enough research material to corroborate your claims, I mean, it's not very difficult. And also read legal articles, because then you will be able to analyze legal questions and you will be able to put something down on papers.
So the next question is from Savarni Sharma. She asks, can you please tell us again about the 3 R's you mentioned in the beginning?
Yeah. Revisit, rethink, and revise.
Okay.
So this is related to the mood problem. You can go back to your mood problem when you think or when you don't think your strategy is the best strategy.
So Shahbaz asks the next question, and that is, we are not allowed to argue what's not mentioned in the memorial. How to smartly exclude something from the memorial and bring it up during the arguments?
Yeah, this is an interesting question, and this is really very subjective, because this is actually situation centric. This is correct that you are not allowed to argue which is not mentioned in your memorial. But see, if there is a case law, let's say case Vananda Bharti. So you have 7 judges who said that Parliament doesn't have the power to amend the basic structure of the Constitution. And you have already included what Justice H.R. Khanna said. So he said, he covered 4 aspects, and you have already included all these 4 aspects. But out of these 4 aspects, there is some important information that is still missing, and you would like to bring it to the notice of your judges. Then you can surely bring it forward. Or any latest development that must have taken place. So if you submit your memorial on, let's say, 30th April, and you have your moot court competition oral rounds in June. So you have 1.5 months or 1.5 months. And in this 1 month or 1.5 months, there is an important development. You can surely cite that.
So the next question is from Srishti, and she asks that can there be a combination of various resources while someone is drafting their memo?
Yes. It should be. Yeah. Combination is allowed. It should be a good blend of all these sources, and you should not just focus on case laws or any other particular source, any other particular. I mean, if you want to include commentaries, if you want to include case laws, if you want to include legal articles, go ahead. No one is stopping you.
Then Basant asks that does dissenting judge opinion matters even though it was outnumbered by majority of judges?
Yes, it does matter. It does matter. I give you an example. So today we have this fundamental right to privacy. But in 1962, or for that matter, in 2010, this right wasn't a fundamental right. But in 2017, 18, it is a fundamental right. So that opinion does matter. Because what was already stated in 1970, but because what has already been stated in 1962 is reiterated in 2017. And you must study this judgment because sometimes judges refer to the dissenting opinions. So, for example, Justice Nariman, he talks about three important dissents, and this dissent of Justice Case Is Overruled is one of them. Justice U. Lalit made a speech on important dissents in Indian constitutional democracy, something like this, and this was one of the most important dissents. So you can refer to these speeches, and you can also cite these speeches or these writings, or I mean something authored by any judge or any lawyer.
Okay.
But only when it, I would like to add, but only when it is, but only when it is a good law. And if you think that this will actually make your case stronger, then you should cite dissenting opinions. Otherwise, there is no need.
Okay. Shall I continue with the question?
Yes, sure.
Yeah. So Nandini asks how to respond to the cross questioning by the judges if you do not have a strong argument in that particular context.
Participate in as many competitions as you can. This is related to oral submissions. Sometimes what happens, they try to shatter your confidence. They try to break your spirit. But if you are thick-skinned and if you think you will be able to defend your case or you will be able to justify, then do it. But please remember that you have to be knowledgeable. It's not like that you are repeating the same thing, right? So you have already argued that you have already put forth your argument A. Now, you're not required to repeat it again and again, right? So this is the only strategy, and practice as much as you can, because they will ask a lot of questions. Those questions may or may not be related to the topic that you are studying. So just be prepared.
So Alsaba asks a very genuine question and very imperative also. Like, what if we couldn't find a case law related to a moot problem? What are the alternatives?
This is an interesting question, but this is, this will never happen. If you think that there is no case law which can concretize your claims, then let me tell you that you are not progressing on the right lines. You are doing something really wrong because you will find case laws. Now, it doesn't matter if there are case laws. So let me give you an example. In Puttaswamy, Justice Chandrachud, or I should say the entire court, referred to American case laws. Case laws which have already established that right to privacy is a fundamental right. So if you think that Indian judiciary hasn't explored this subject or this topic, then you can refer to cases of other jurisdictions. But again, these cases will not be binding, but will only have some value. I would not even say persuasive value, because the Supreme Court of India can exercise its discretion anytime. So, but yes, I do not agree that you will never find a case law. You will surely find a case law. Now that depends whether that case law is of the Supreme Court or any other high court.
So a follow-up question on this specific issue is asked by Shahbaz, and he says that how to research on issues which are still not regulated by Indian law. For example, cryptocurrency. So there are no laws and no judgments on this topic.
But as I said, that there are many reports or there are some articles, and you can refer to some other jurisprudence. I mean, jurisprudence of other countries, and you can surely substantiate your claims. So let me give you an example. There is this judgment, Cryptopia versus Rusco Moore, delivered by the High Court of New Zealand. And in this judgment, there is this interplay between insolvency and cryptocurrency. Now, New Zealand hasn't explored this area, but they refer to English jurisprudence. So they have cited 5 to 6 case laws. They have referred to some committee reports or some government reports, which were published by the government of United Kingdom. So this is how they have developed their law, right?
So Daksh, now we'll take another 2-3 questions which we received earlier from our participants.
Sure.
So Lalit Kumar has asked, how can beginners develop a mindset which helps them prepare for moot court practices and competitions?
Okay, so this is for T-Rose, this is for beginners. There is some interesting literature available on moot court, and as I said, that if you want to know what mooting is, then you can refer to the Oxford Guide. If you want to watch moot court competitions, just start Googling it. There is this AMES moot court competition organized by the Harvard Law School. You can watch that, and please read as much as you can. If you want to read your case material, read it. If you want to read your articles, read it. If you want to study anything, related to law, do it, because this will surely pique your curiosity. So, for example, there are many journals published by the Faculty of Law, University of Delhi. There are many articles published in these journals. If you are interested in constitutional law, select 2 to 3 articles, read these articles, try to analyze the question of law. There are some astute questions of law that these articles deal with. Analyze these questions, start expressing yourself, watch the moot court competitions videos, and start looking for these guides, Cambridge Guide, Yale Guide, Stanford Guide, and after 10 days, you will see that you are prepared. Prepared to participate in a moot court competition, not to win it, of course, but prepared to participate in a competition. So inculcate this habit, read as much as you can, and examine or analyze as much as you can.
So the next question is from Shivratri, and she asks, how can we learn to use legal jargons in memorial as a beginner?
As a beginner, no, you won't be able to use it. If you're a beginner, you won't be able to use it because this requires a lot of practice. This can be taxing as well, because sometimes people use different legal jargons. Wrong legal jargons when the intended meaning is different. But you can refer to this guide published by the National Law School, Delhi. So they have this comprehensive guide which deals with the legal jargons and legal maxims. But again, the usage of these maxims, these jargons, depends on how you want to convey. But initially, I would suggest that please focus on plain English. And of course, read judgments. Read judgments delivered by the High Court, Delhi High Court, or the Supreme Court, because you will see the correct usage of legal jargons or legal maxims.
So we'll just take this last question. So
Yeah.
It's a kind of a general question and very interesting one also. So Amisha asks, how much does moot court experience help lawyers in their careers, and how was your moot court journey?
Moot court experience help lawyers, I don't know. Just enjoy it. I don't know if it helps or not, because if I have to give an example, Justice Nariman Nariman, one of the best lawyers, one of the best judges, and he didn't participate in any moot court competition. But if you ask him to argue insolvency case, he would be able to do it. If you ask him to argue constitutional law case, he would be able to do it. And he didn't participate in any moot court competition. So if I talk about top-notch lawyers, big lawyers, advocates, they haven't participated in any moot court competition. And this is just for fun. And if I talk about my moot court journey, I've been the most a successful failure because when I used to represent Campus Law Center, I didn't win any moot court competition. But so at Campus Law Center, we have internal rounds. And I used to participate with a very good friend of mine, Aggarwal. And every time we used to participate in the internal rounds, we used to win. But when we represented Campus Law Center, we lost. So I don't know what happened. Maybe we didn't plan it correctly, or I don't know. But yes, it was fun because you get to meet other people, you get to know more about the law. And the best thing is you get an opportunity to analyze the legal question that you are most interested in. So that's the biggest takeaway from any moot court competition.
Thank you, Daksh. Thank you for the session, and thank you for taking all these questions and answering them in such a lucid manner. So thank you
so much.
Over to you, Anjali.
Thank you, Vivek. And if I may just add to what Daksh was talking about, how mooting helps in being a lawyer. It's like what Daksh said is pretty right, that, it will not translate as it is into you becoming an amazing lawyer, but it gives you the wherewithal to start. So if you go into the profession without ever knowing what an SCC is and you find yourself in a law chamber, you will feel completely lost. If you don't know how to form an argument and you've never done it before, you'll find it very difficult to start from scratch in a law chamber. So these skills really help you when you do start in the career. Of course, everything else you have to learn on the job. The actual career is very different from the way, the idealistic setting in which we moot. So it gives you the bare skills to start with, but everything else you learn on the job is what my experience has been.
And yes, I welcome feedback and constructive criticism. So I would like to hear from you. If you would like to suggest something or something that I should have included or excluded, please let me know. I'll just share my mail ID.
That's very gracious, Daksh. You can just share it in the chat box. And any of the participants, if they'd like to get in touch with Daksh for the feedback or for any other guidance, they obviously are welcome to do that.
Yes, always available. Yes.
Great. So before I begin my vote of thanks, I would like to inform all our participants that there will be a feedback form in the chat. This feedback form especially pertains to the technicalities of this workshop and how your experience of this workshop was. Any personal feedback for Daksh can obviously be communicated to him. I'd like to begin by thanking Daksh for sharing his time and expertise with us. All of us have greatly benefited from your invaluable insight into the nuances of memorial drafting. I would like to extend gratitude to our teacher convener, Professor Kiran Gupta, and all our faculty members for encouraging and enabling this event, especially to Ashutosh sir and Ajay sir who have lent us support to put up this webinar. A big thanks to the team at the Moot Court Society, the executive committee that has made this event possible. I would like to thank all our participants for making this a success. Thank you for joining us today. I hope you have a wonderful evening. Thank you, guys.
Thank you. Thank you, Anjali. Thank you so much.
Thank you.